Welcome to today's presentation, How to Apply for a Green Card Based on Family Relationship. There are 5 steps to obtain a family-based green card. Step 1. The American relative, either a U.S. citizen or a lawful permanent resident, files Form I-130. Step 2 is a waiting period. The parties are waiting for the petition to be approved. Step 3. The immigrant receives a visa number from the Department of State. Step 4. If the individual is in his home country, he will go through consular processing at the U.S. consulate or embassy in his home country. Or if the individual is in the United States, he will file for adjustment of status. Step 5. The immigrant receives his green card. Today we will cover Step 1. The American relative or lawful permanent resident files Form I-130. Step 1. Determine if the non-citizen is eligible to apply for a green card while in the United States at the time the petition is filed. That means the individual has to be physically present within the United States at the time the petitioner or the sponsor files the I-130 on their behalf. There are 2 categories under which an individual may file: immediate relative of a U.S. citizen, or family-based preference categories for a U.S. citizen or a lawful permanent resident. In order to qualify for the immediate relative of a U.S. citizen, the person has to be a spouse of a U.S. citizen, the unmarried child under the age of 21, or a parent of a U.S. citizen who is at least 21 years old at the time the petition is filed. In order for an individual to file under the family-based preference categories, the individual has to be the family member of a U.S. citizen who is unmarried, son or daughter 21 years old or older, the married son or daughter of a U.S. citizen, or the brother or sister of a U.S. citizen who is at least 21 years old. In order for a lawful permanent resident to apply for a family member, the individual has to be the spouse of a lawful permanent resident, the unmarried child under the age of 21 of a lawful permanent resident, or the unmarried son or daughter of a lawful permanent resident 21 years old or older. Step 2. Prepare a petition for alien relative, Form I-130. This form establishes the family relationship that exists between the U.S. citizen or lawful permanent resident and the alien they are asking the immigration agency to approve to reside within the United States legally. The petition for alien relative is prepared by the petitioner or sponsor, that means the U.S. citizen or lawful permanent resident. That individual must include their address history for the past 5 years, dates of any previous marriages, divorce decrees terminating any previous marriages, employment history for the past 5 years, and any petitions that he or she has filed before for either this beneficiary or any other alien that they have asked the U.S. government to approve to reside within the United States. If the petitioner is a U.S. citizen, that U.S. citizen should submit a birth certificate, passport, naturalization certificate, certificate of citizenship, or consular report of birth abroad proving that he is a U.S. citizen. If the petitioner is a lawful permanent resident, they should also submit a copy of their green card, both front and back, and other proof of permanent residence. Step 3. Prepare the supplemental information for spouse beneficiary, Form I-130A. Note, this form is only necessary if the petitioner is the spouse of the beneficiary, the immigrant. The beneficiary must provide birth certificate issued in another country, address history for the past 5 years, dates of previous marriages, divorce decrees indicating termination of the previous marriages. If the marriage terminated due to the death of the former spouse, the beneficiary will need to provide a death certificate of that former spouse from the foreign country, employment history for the past 5 years, U.S. visa if the individual is presently in the United States, Form I-94 information, any previous immigration proceedings including removals, deportations, or detentions, and records of previous interactions with law enforcement, which simply means any cases that were filed with the police department, in a criminal court of law, any civil court of law, or any matter in which you were fingerprinted, detained, held overnight. The immigration agency is going to want to know the outcome of those incidents, and you will have to provide written proof of those incidents. Step 4. File the petition for the alien relative Form I-130 and supplemental information for spouse beneficiary Form I-130A with U.S. Citizenship and Immigration Services, also known as USCIS. You may file the petition online or mail the petition to the designated USCIS lockbox. It's always best to look up the address for your lockbox. There are several, and they may change depending on when you file the Form I-130 and the I-130A. You must include the filing fee of $535, or your petition will not be reviewed. The money is non-refundable. Basically, that means whether or not your petition is approved is irrelevant. They will not refund the money to you if the petition is denied. And you must attach copies of all supporting documentation. Do not send your original documents. Those will be with you when you go to the immigration agency for your interview. So again, copies of all supporting documentation. Do not send original documents. You will present those during your interview with the immigration agency. We'd like to thank you for taking the time to review our presentation today. If you would like to receive assistance with your family-based immigration case, please feel free to contact us at 713-568-6910, or you can reserve a consultation online at atonyamcclainlaw.com. Again, our number is 713-568-6910, or you can go and book a consultation yourself online at atonyamcclainlaw.com. We look forward to hearing from you, and again, thank you for taking the time to view our presentation today.